Mr. Matthews?
That is all correct, Your Honor.
All right, Mr. Stenard, how old are you?
25,
How far did you go through school?
12th grade.
Are you a U.S. citizen?
Yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
Have you ever been diagnosed with or treated for any mental illness?
no,
Did you get a copy of this indictment?
yes,
All right, it's been represented to me that you're going to plead guilty to the lesser included offense in count 1, robbery, a felony 3, count 2, strangulation, a felony 4, and count 5, failure to comply with the order or signal of a police officer, a felony 3, and then the remaining counts would be dismissed at sentencing. Is that your understanding?
yes,
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want more time to talk to Mr. Matthews, let me know and I'll give you more time. Do you understand that?
yes,
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
yes,
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
yes,
If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
yes,
Do you have any questions about any of these rights?
no, sir,
Do you still want to plead guilty to these counts?
yes,
Do you understand by pleading guilty, you're fully admitting your guilt to these charges?
yes,
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
yes,
The lesser included offense in count 1, robbery, is a felony 3, carries a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
yes,
Count 4, strangulation, is a felony 4, carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
yes,
Count 5, failure to comply with the order or signal of a police officer, is a felony of the 3rd degree, and that carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
yes,
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, then you face a maximum prison term of 90 months and a maximum fine of $25,000. Do you understand that?
yes,
You further understand that any prison sentence, that the count 5 failure to comply would be consecutive to any other prison sentence. Do you understand that?
yes,
Now, are you on post-release control to the parole authority?
yes,
And you're on, as I understand it, until October 1 of 25? Does that sound right to you?
Parole?
Yes.
Yes.
Okay. Now, in addition to any sentence on this case that we're here for today, I could give you an additional consecutive prison sentence for your post-release control violation. Do you understand that?
Yes.
And if I did that, the maximum that I could give you would be 364 days. Well, at this point, 364 days, but at the time of sentencing, whatever is left under post-release control. Do you understand that?
Yes.
Any questions about that?
No, sir.
I think, Your Honor, I'm sorry, just for,
Yep.
I think the maximum sanction he would face would be 12 months.
Right, I could give you either 12 months or whatever's left, whichever is more. Okay, thank you, Mr. Matthews. Do you understand that?
Yes.
Okay. Do you understand that your guilty plea with regard to count 5, where are we at in the timeline? 3 to life or more than that?
I
For
believe
the
it's-
license suspension, yes, it's a definite period of 3 years to life.
Okay, so on count 5, you face a mandatory license suspension of at least 3 years up to your lifetime. Do you understand that?
Yes.
Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, when you are released, you will be on post-release control for at least 1 year, up to 3 years under the parole authority?
Yes.
They will place conditions on you. If you violate their conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 90 months. Do you understand that?
Yes.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Matthews before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No, sir.
All right, Ms. Alessi, if this case went to trial, what would the evidence show?
The evidence would show that on July 2nd, 2024, in Lake County, state of Ohio, Daviana Cullum, a resident, at Fox Run Apartments, called dispatch to report that she had been assaulted. She advised that she was injured and that the defendant stole her vehicle, which was a black Grand Cherokee. The victim was visibly upset when officers made contact with her, and she had blood on her lips and teeth and was complaining of head pain and dizziness, and she was subsequently transported to UH Lake West for treatment. Cullum stated the defendant had asked her to use her vehicle, and she said no. The defendant rushed at her, grabbed the keys out of her lap, where a physical struggle ensued. The defendant ended up punching her in the face, kicking her, and while she was on the ground, he began to strangle her with both hands around her neck. Cullum did not lose consciousness, but described that it was hard to breathe, and she did have red marks around her neck. The defendant was able to get the keys and ran out of the apartment, taking the vehicle. The defendant was on parole at the time and was wearing a post-release control, and was wearing a GPS monitor. Willoughby officers were able to communicate with the parole officer and track the defendant's location. They put out a bolo on the vehicle where Wickliffe PD was able to observe the vehicle on Interstate 90. Officers attempted to stop the vehicle, but the vehicle fled at a high rate of speed, exceeding 90 miles per hour in a 60 miles per hour zone. Traffic was moderate. The officers were actually having a difficult time pursuing the vehicle because of the traffic. The Jeep merged into the express lanes just before exiting, cutting across the grass median, almost causing an accident with the local lanes just before Wilson Mills. At that point, officers terminated the pursuit. Willoughby officers and the United States Marshals Violent Fugitive Task Force later found the vehicle abandoned on Apollo Parkway and found the defendant's cut off ankle monitor. And around 7 hours later, Lieutenant Seville with Willoughby Police Department found the defendant sitting on the patio at the River Tavern and took the defendant into custody. The defendant was Mirandized, and he stated nothing physical had occurred, that he was on his way back with the vehicle when he fled from an unknown police department. And Ms. Cullum is a family or household member with the defendant. She shares a child with the defendant. Thank you.
Thank you, Mr. Matthews. Anything to add to the facts?
No, Your Honor.
Mr. Stenard, did you hear what Ms. Alessi said the facts would show if this case went to a trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea to the lesser included offense in count 1, robbery, a felony 3?
Yes.
What is your plea to count 2, strangulation, a felony 4?
Yes.
And what is your plea to count 5, failure to comply with the order or signal of a police officer, a felony 3?
Yes.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Mr. Stenard. He indicated that he understood it and that he intended to sign it.
Is that correct, Mr. Stenard?
Yes.
All right, if you want to plead guilty, then you need to sign that document.
Okay. Put the date on that line, 10/2/24.
The defendant and his attorney have signed the written plea of guilty here in open court, and I've signed it as well. May I approach?
All right, Mr. Stenard, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Mr. Matthews advised of all of his rights. In a knowing, intelligent, voluntary waiver of those rights, he understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary, I will accept his plea of guilty. Find him guilty of the lesser included offense in count 1, robbery, a felony 3. Count 2, strangulation, a felony 4. Count 5, failure to comply, a felony 3. Refer this for a pre-sentence report, victim impact statement. Sentencing is November 20, 3 p.m. Bond is revoked. Anything else, Ms. Alessi?
No, Your Honor. Thank you.
Mr. Matthews?
No, Your Honor. Thank you.
All right, we're adjourned.